You're listening to the Valley Current.
Imagine for a second that you are walking into a federal courtroom.
Oh, that is a stressful thought right out of the gate.
Right. I mean, it is one of those imposing rooms, you know, the type. The dark mahogany panels, the giant American flag hanging heavy behind the bench.
The absolute institutional silence in the air.
Exactly. The air is just thick with it. And your entire future, or, you know, maybe the future of your company is just completely hanging in the balance.
Yeah.
You spent years preparing. Your legal team has spent hundreds of hours, probably hundreds of thousands of dollars, crafting these arguments.
Oh, at least.
Opposing counsel has made theirs. And the judge is sitting up there at the bench, looking down at this literal mountain of paperwork, deciding your fate. But right before they issue the ruling, they pause.
Okay.
They turn to a secondary monitor, bring up a little chat window, and quietly ask an artificial intelligence model to, you know, see what it thinks about your case.
Wow. Yeah, when you frame it like that, it sounds completely absurd.
It sounds like science fiction. It sounds like a movie set 50 years in the future.
Right.
But the crazy part is, we are not talking about science fiction today.
Oh, we are not.
We are talking about reality. This is actively happening, like right now, behind closed doors, across the entire American justice system.
It really is happening.
Yeah.
And the reality of how it's unfolding is actually way more nuanced and, frankly, a lot more precarious than, you know, the sensationalized headlines would have you believe.
Right.
We're standing at this highly specific, very fragile inflection point for the judiciary. I mean, the technology has officially arrived in chambers, but the rule book just hasn't entirely caught up yet.
And that gap between the tech and the rule book, that is exactly our mission for this deep dive today. We're unpacking a genuinely fascinating, incredibly well-researched technology and intellectual property briefing.
It is a great document.
Yeah, it's from June 25th, 2026, written by Jack Russo from Computer Law Group, LLP. And the title just asks this million-dollar question: are the courts starting to embrace AI? It's such a simple question, but the answer is so complicated.
Totally. So we are going to look past the hype to see what judges are actually doing when those heavy chamber doors are closed. Mm-hmm. We're going to explore how individual state courts are basically turning into like real-time laboratories for AI policy.
Yeah, the state-by-state split is wild.
We'll get into all of that. And we're going to dive deep into why the biggest problem in law right now actually isn't rogue robot judges. It's, well, human beings who just blindly trust the machines.
Always the human error.
Right. So whether you are an attorney prepping for a massive litigation meeting, or maybe an executive tracking enterprise tech trends, or if you're just insanely curious about the future of human judgment itself, settle in. We are mapping out the exact state of AI in the American judiciary as of summer 2026.
A lot of ground to cover.
It is. And to start us off, there is this central analogy from the briefing that I think just perfectly frames the whole dynamic. The briefing suggests that we really need to stop thinking of AI as some robot overlord.
Instead, we should think of it as an extraordinarily well-read law clerk.
I really love that mental model because a traditional law clerk, who is usually this brilliant, very tired, recent law school grad, they are a judge's right hand.
They do all the heavy lifting, right?
Exactly. They read the cases, they draft memos, they prep the judge. Now, just imagine a clerk who works in milliseconds, a clerk who literally never needs to sleep.
And has memorized the entire internet.
Right. They've memorized every single appellate case ever published in the history of the United States. So if you are a judge with a crushing docket, say hundreds of open cases, and you have a clerk who can summarize a 1,000-page trial record before you even poured your morning coffee.
That sounds like an absolute godsend.
It is a godsend. But
there's a massive catch.
Oh, huge catch. Because the briefing points out that this seemingly magical clerk has a fatal flaw.
The hallucinations?
Precisely. This incredibly fast, brilliant clerk will also occasionally just make things up completely out of thin air.
Just lie to your face.
And worse than just lying, they will present those total fabrications to you with absolute unwavering confidence. They don't say, I'm not sure about this.
Right, they don't hedge.
No hedging at all. They will hand you a fake precedent and tell you it is the binding law of the land.
Yeah.
So it really highlights both the immense appeal and the sort of existential danger for the judiciary.
That makes total sense. So my immediate question is, knowing that this quote-unquote clerk occasionally just completely fabricates reality, how many judges are actually inviting it into their chambers? Like, are they keeping the doors locked or are they playing around with it?
They are definitely experimenting. widely but quietly. And we actually have some really fantastic hard data on this now, which helps ground the conversation.
Oh, from the Northwestern study.
Yeah, the random sample survey conducted by Northwestern University and the Sedona Conference. This came out in March of 2026.
Okay, what did they actually find? Because I feel like judges would be super conservative about this.
You would think so. But the numbers paint a picture of, well, widespread curiosity. They found that 61.6% of responding federal judges have used at least one AI tool in their judicial work.
Wait, hold on. Over 60%. That is a clear majority of the federal bench. I would have guessed way lower.
I know it's high, but you have to remember the pain point of their workload is incredibly high. They are desperate for efficiency.
Okay, fair point.
But, and this is key, the frequency of use tells a slightly different story.
Meaning they aren't using it all day, every day.
Exactly. While a majority have tried it, only 5.4% are using an AI tool daily.
Okay. So a very small, hardcore user base.
Right. And another 22.4% use one on a weekly or daily basis. And then nearly 40% have literally never touched it at all.
So the Northwestern data basically shows that experimentation is absolutely mainstream, but like heavy habitual reliance isn't quite the norm yet.
That's the perfect way to summarize it.
Okay, let me get my head around this. If a clear majority of federal judges are playing around with these tools in chambers, they have to have some sort of framework for what is acceptable, right? Like they can't just be throwing highly classified federal trade secrets into a public chatbot.
You would hope not.
The briefing talks about this universal compromise that courts have landed on. They call it the permission gradient. Can you walk us through how that actually works in practice?
Yeah, the permission gradient is a really fascinating conceptual framework. It shows up in almost every governing document and ethics guideline reviewed in the briefing.
So it's like a traffic light system.
Kind of. It basically categorizes judicial work into three distinct zones: green, red, and black. And the core philosophy across all of them is that the machine can help you prepare to judge, but it absolutely cannot do the actual judging.
Okay, let's unpack this and take those one by one. What exactly is the green zone?
The green zone is the permitted area. Think of this as the junior assistant model we were just talking about.
So safe tasks.
Right. This includes tasks like summarizing voluminous documents, running initial legal research, maybe organizing the complex timeline of a case,
Okay.
or drafting a first pass at some routine procedural questions for an upcoming oral argument. It is all the heavy lifting that happens before a decision is ever made.
Makes sense. It's prep work. And the red zone.
The red zone is strictly prohibited. This is the adjudicative function itself.
The actual judging.
Exactly. This means weighing the facts of a case, determining the credibility of a witness, and deciding the final legal result. The framework treats adjudication as a completely non-delegable human function. You cannot ask the machine, hey, who should win this case?
Right. And then what's the black zone?
The black zone is all about confidentiality. It is an absolute hard bar against entering sealed, privileged, or sensitive personal data into an open public AI tool.
Because it could be absorbed into the training data.
Precisely. You don't want a private corporate merger detail showing up in someone else's ChatGPT prompt the next day.
Okay, I see the logic of the green, red, and black zones. It sounds neat on paper, but I have to push back on this a bit.
Please do.
I look at this red line, this supposedly ironclad wall between preparing in the green zone and adjudicating in the red zone, and it feels incredibly porous to me.
How so? Like, where do you see the leak?
Well, let me pose a practical scenario.
Yeah.
Let's say a judge has a super complex antitrust case, and they ask an AI tool to summarize a 1,000-page trial record.
A classic green zone task.
Right. But the AI has to make algorithmic decisions about what is important enough to include in, say, a 5-page summary, and what is irrelevant enough to leave out.
Yeah.
Isn't that choice, the choice of what to highlight and what to obscure, isn't that quietly adjudicative? If the AI decides to leave out the defendant's winning legal argument from its summary, and the judge relies on that summary, hasn't the machine effectively made the ruling without anyone even realizing it?
That is an incredibly sharp observation, and honestly, you have just articulated the exact fear that keeps appellate judges awake at night.
Really? So they know this is a problem.
Yeah. Oh, absolutely. The delegation of attention is a form of silent adjudication. And that is precisely why the prevailing rule across these frameworks isn't just trust the machine. The rule is trust, then verify.
Meaning the judge still has to go back and read the underlying documents anyway.
Exactly. What Jack Russo argues in the briefing is that we don't actually need to invent a brand new philosophical framework to solve this summary problem.
We just use the old rules.
Right. We just apply the rigorous discipline that good judges already use with their human staff. Think about it. A judge with a human law clerk doesn't just blindly sign whatever memo the clerk drops on their desk.
Right. They read the clerk's memo, but they still go pull the original case law to make sure the clerk interpreted it correctly.
Precisely. The clerk drafts, the clerk flays the issues, but the judge ultimately tests the logic. If a judge wouldn't hand a 25-year-old human clerk the gavel and say, hey, you decide this one, they certainly shouldn't hand the gavel to a language model.
That makes sense. The signature on the bottom of the order has to stay with the human.
Always. The ultimate responsibility is human.
So the line holds theoretically because the human is supposed to check the work. But how does a system as massive and decentralized as the U.S. judiciary actually govern this? Because from what I'm reading in the source material, the federal government's approach to this is essentially crickets.
Yeah, crickets is a very good word for it. It is perhaps the most defining and honestly perplexing fact of judicial AI right now.
The lack of rules.
The absolute absence of a national judiciary-wide federal policy governing how judges use AI. The Judicial Conference of the United States, which is the national policy-making body for the federal courts, they just haven't issued a binding rule on this.
Wait, didn't Chief Justice Roberts say something about it?
He did. Chief Justice John Roberts warned about dehumanizing the law back in his 2023 year-end report. But no overarching mandate, no strict rule book ever actually followed from the top.
Wait, I want to make sure I'm really understanding this. There is no federal rule at all. A federal judge in New York and a federal judge in California are just making it up as they go along.
Essentially, yes. They're running their own courtrooms. Now, there is exactly one formal federal motion moving through the system right now regarding AI, but its scope is incredibly narrow.
What's the motion?
It is proposed Federal Rule of Evidence 707.
Okay, what does Rule 707 actually do?
Well, to understand Rule 707, we need to talk briefly about how evidence works in a federal trial. Historically, judges act as gatekeepers for what a jury is allowed to see.
Right, they keep the bad stuff out.
Exactly. If you want to bring in a scientific expert or a complex piece of technical evidence, the judge evaluates it using something called the Daubert framework.
Daubert, I've heard that term. What does it actually mean in plain English?
It comes from a famous 1993 Supreme Court case, Daubert v. Merrill Dow Pharmaceuticals. It basically says that before expert testimony or scientific evidence can be presented to a jury, the judge has to ensure it is rooted in scientifically valid reasoning and methodology.
So it's designed to keep junk science out of the courtroom.
Exactly. Junk science, unproven theories. Now, Rule 707 is essentially an extension of that Daubert philosophy, but specifically for AI.
Oh, I see.
It targets AI-generated evidence offered by litigants to a court, say, an AI simulation of a car crash, or an AI analysis of complex financial records.
So if a lawyer tries to show a jury a computer-generated video of an accident, Rule 707 kicks in.
Right. It subjects that evidence to strict reliability screens. But here is the key distinction for our conversation. Rule 707 has absolutely nothing to do with judges using AI tools themselves.
Oh. It doesn't govern their own desktops.
Not at all. It doesn't stop a judge from using an AI to write an opinion or summarize documents.
I see. It polices the evidence the lawyers bring in, but not the judge. But even as a rule for evidence, hasn't Rule 707 received a ton of pushback? The briefing mentions a major critique from the New York City Bar's Federal Courts Committee.
Yeah, they pointed out a massive glaring loophole in the proposed rule.
Which is?
Rule 707 only triggers if the AI evidence is acknowledged.
Sweet.
Exactly. If a lawyer stands up in court and says, Your Honor, we offer this AI simulation of the accident, then Rule 707 kicks in and the judge tests its reliability.
But what if they don't say it's AI?
That's the loophole. The rule completely misses the undisclosed malicious use of AI. It doesn't do anything to catch the secretly altered audio recording of a CEO or a deepfake video of a crime scene where literally no one admits an AI was ever used.
Wow. That is a huge blind spot.
The Bar Committee argued strongly that the undisclosed deepfake is a far more dangerous threat to the justice system than the transparent, acknowledged AI simulation.
That makes total sense. I mean, if someone is actively trying to sneak a deepfake past a jury, they aren't going to raise their hand and say, hey, judge, please apply Rule 707 to my fake video.
Right. Bad actors don't ask for permission.
So officially, at the federal level, you have this huge vacuum, no rules for judges, and a heavily criticized proposed rule for evidence. What happens when the top-down guidance simply isn't there?
Well, nature abhors a vacuum, and so does the legal system. Because the federal policy isn't there, we are seeing these fascinating grassroots, judge-driven solutions organically filling the void.
Like a bottom-up approach.
Exactly. The most prominent example the briefing highlights is the Judicial AI Consortium, or the JAIC.
JAIC. Tell me about them. Who are they?
This launched in early 2026. And it is an extraordinary initiative because it's completely vendor-free, judges-only forum.
Meaning that software companies can't come in, sponsor a lunch, and try to, sell their latest legal tech to the bench.
Precisely. No sales pitches, no outside pressure, just a secure private environment for judges to talk to each other.
That's smart. How did it start?
It grew out of conversations between a few plein air judges who basically realized they couldn't wait for Washington to figure this out. The briefing specifically calls out Magistrate Judge Maritza Dominguez Braswell in Colorado, Judge Scott U. Schlegel in Louisiana, and Judge Xavier Rodriguez in Texas.
The trailblazers.
Yeah, they really are. And the consortium now has about 325 members. They hold these quarterly forums where it is literally just judges asking other judges, hey, how are you handling this specific privacy issue? What prompts are you using to summarize testimony?
It's like a highly exclusive support group for the judiciary.
In a way, yes, it really is. And parallel to that, you also have the National Center for State Courts and Thomson Reuters forming a collaborative consortium.
Are they just for judges too?
No. They are focused on AI literacy across the entire court system. They aren't just looking at the judges. They are trying to educate the court reporters, the clerks, the administrative staff. Everyone who touches the judicial process needs to understand what this tech is.
Which is an amazing grassroots effort, honestly, but it also highlights the absolute chaos of the moment.
It does.
Because while the federal judges are forming these informal study groups, the state Supreme Courts are just plowing ahead and writing their own rules.
Ooh, the states are moving fast.
The briefing maps this out, and it's fascinating to me. We are essentially watching a massive natural experiment happen in real time across the individual states. And the states are coming up with entirely different, sometimes completely opposite answers to the exact same problem.
The divergence is wild.
Let's look at Illinois, for example.
Illinois is a perfect place to start. They took a highly permissive stance. Their policy basically says to their judges and lawyers, look, we recognize this technology is here. We expect you to use it. It is authorized.
Okay, pretty progressive.
But the most interesting part of the Illinois approach is what they don't require. They explicitly state that no disclosure is required.
Wait, really? You do not have to tell the court that you used an AI?
No, you don't have to tell the court or the opposing counsel that an AI helped draft your brief. You can just use it.
You can just use it in secret. That is wild. Now, compare that to Delaware, because from the briefing, Delaware went in the complete opposite direction.
Delaware is a fortress.
Right. They instituted a strictly gated architecture, and it makes sense, right? Delaware handles some of the most sensitive corporate litigation in the world. Mergers, acquisitions, massive trade secrets.
Exactly. The stakes are huge there.
So they basically said you cannot use just any public chatbot. You can only use tools from an approved Gen AI list, specifically to ensure that confidential corporate data isn't being fed into public models and leaked out.
Yes. Delaware builds a protective fence. And then, if you look out west to Utah, they took a different path entirely, a supervised approach.
What does Utah do?
Utah legally mandates human review of AI outputs. And they actually force lawyers and judges to issue explicit warnings about AI bias in their workflows.
So they are trying to legislate the human verification step, like forcing you to acknowledge the tech's flaws.
Right. And then there's New Jersey, which honestly seems like the most proactive of all of them.
Yeah, the New Jersey example blew my mind. They didn't just write a rule on a piece of paper. They physically built a software tool.
They did. They took a public AI model, stripped it down, put it inside a secure, walled-off judiciary infrastructure, and then just let their staff loose on it to query their own internal documents.
The briefing notes they started with a tiny 11-person pilot program in early 2025. And by early 2026, they had over 2,000 internal users in the New Jersey court system using this custom tool.
It is a remarkable divergence across the country. You have 4 states and 4 entirely different regulatory philosophies.
To summarize, Illinois trusts the user, Delaware builds a protective fence, Utah mandates human supervision, and New Jersey builds its own proprietary sandbox.
Perfect summary.
But I have to challenge the Illinois model here. I am looking at this from the perspective of a litigant, like a normal person involved in a lawsuit.
Okay, put yourself in their shoes.
Right. If a lawyer in Chicago doesn't have to disclose that they used an AI to rate their brief, How does the judge know the lawyer actually took the time to verify the output? Without a disclosure requirement, doesn't that just encourage lazy lawyering?
I see where you're going with this.
Doesn't the Delaware approach, where you have approved tools to protect data and strict parameters, just make significantly more sense if you actually care about the integrity of the judicial process?
It is a very fair critique, but we have to understand the underlying assumption beneath the Illinois rule. Illinois is making a bet.
What kind of bet?
They are betting that the existing ethical duties of a lawyer, specifically the duty of competence and the duty of candor to the court, are already enough to police bad AI use.
Oh, I get it. So the rules we already have.
Exactly. Think about it mechanically. If you submit a legal brief filled with fake cases, you are going to get sanctioned by the judge, whether you used an AI to write it or whether you just hallucinated the cases yourself after a long night at the firm.
Right. Bad work is bad work.
Illinois views a separate, specific AI disclosure mandate as redundant friction. They don't care how you wrote the bad brief. They only care that the brief is bad.
So they're just focusing on the final product.
Delaware, on the other hand, isn't just worried about bad briefs. Delaware is terrified of data leakage.
Ah, right. The corporate secrets.
They are betting that the risk of a lawyer accidentally feeding a client's multi-billion-dollar trade secret into a public chat bot, which then uses that secret as training data for the whole world, is so incredibly high that a curated tool's perimeter is the only way to keep the system safe.
But think about what this means on the ground for a practicing attorney. This creates total jurisdictional chaos.
It is a mess.
I like to think in analogies. Imagine you are driving across the country with a radar detector on your dashboard.
Okay.
In one state, it's perfectly legal, you're fine. Then you cross an invisible line on the highway and suddenly it's a crime and your car gets impounded. That is exactly what is happening in the law right now.
It's a great analogy.
Imagine you are a litigator. You write an AI-assisted brief in an Illinois state court. You are perfectly in compliance. You don't disclose a single thing.
You're good to go.
Then you walk 2 blocks over to a federal district court in that exact same city where the local federal judge has issued a standing order demanding an affirmative signed certification that no unverified AI was used in the making of your document.
Right.
A legal brief that is totally fine in one building could be grounds for severe professional sanctions just down the street.
For technology clients, and especially for intellectual property counsel who practice nationwide, this is the absolute nightmare scenario.
I bet.
Until a unified national rule emerges, the seemingly simple question, hey, can I use AI to help write this document, has 50+ different answers depending on exactly where your feet are planted.
It's just a minefield.
It is. And since you mentioned sanctions, that really brings us to the very real, very explosive consequences of lawyers guessing wrong. Because while we have been talking about policy and judges, the actual dominant story of AI in the courtroom over the last 3 years hasn't been about judges using it wisely.
Oh, no, it has not.
It has been about lawyers completely crashing and burning.
Yes, the hallucination epidemic. You really cannot have a serious conversation about legal AI without talking about the cautionary tales. And the briefing traces this entire phenomenon back to patient zero, Mata v. Avianca.
Ah, yes, a famous one.
This happened in June 2023 in the Southern District of New York. For anyone who doesn't follow legal news religiously, this is the legendary case that put AI hallucinations on the map.
It really is the foundational text for what not to do.
Yeah.
We should probably break down exactly what happened because the mechanics of the failure are important for understanding the current landscape.
Okay, let's go through the facts. A man named Roberto Mata sued Avianca Airlines. He claimed he was injured by a serving cart during a flight.
Pretty standard personal injury claim.
Right. The airline's lawyers filed a motion to dismiss the case, basically arguing that the statute of limitations had expired. They said he waited too long to sue. So Mata's lawyers needed to prove that the statute of limitations had not expired. And the lawyer drafting the response did what a lot of people do when they have a question. He just asked ChatGPT to find legal precedent showing that a case like this could proceed.
And ChatGPT, being the incredibly helpful assistant that it is, generated exactly what the lawyer asked for.
It was almost too helpful.
Right. It provided a brief citing several cases, including one very prominent one called Varghese v. China Southern Airlines. And the lawyer took these citations and submitted them in a formal legal brief to Judge P. Kevin Castell.
But there was a massive problem.
A catastrophic problem. The cases didn't exist. They were pure hallucinations.
It's completely made up.
When the opposing counsel for the airline went to look up Varghese v. China Southern Airlines in the official legal databases so they could read the ruling, they couldn't find it.
Because it wasn't there.
Right, because an AI doesn't actually search a database like Google. It predicts the next logical word in a sequence. It knew what a legal citation should look like, so it just invented one that sounded perfectly plausible.
But the craziest part of the Mata story, to me at least, isn't that the lawyer made a mistake. It's the cover-up.
Oh, the cover-up was so much worse than the crime.
When the opposing counsel and the judge came back and said, hey, we can't find these cases, can you provide us with the full text? The lawyers didn't immediately apologize and admit they used an AI.
No, they didn't.
Instead, they doubled down. They actually went back to ChatGPT and asked it to generate the full multi-page text of the fake cases to quote-unquote prove they were real. And then they submitted that fake text to the federal judge.
It remains a stunning, almost incomprehensible failure of professional judgment.
I just can't imagine doing that.
Well, Judge Castell held a hearing, and he ended up sanctioning the lawyers $5,000.
Right.
But the critical precedent that Judge Castell set in his ruling wasn't that using AI is inherently bad.
What was the precedent then?
He explicitly noted in his order that there is nothing inherently improper about an attorney using a reliable AI tool for assistance, just as they might use a legal research database like Westlaw. The sanction was not for using the tool.
It was for the failure to check it.
Exactly. The sanction was for failing the gatekeeping duty to verify the filing and for the subsequent cover-up. He punished the lack of human verification, not the technological curiosity.
Okay, so that was June 2023. But here we are, 3 years later in the summer of 2026, and the problem hasn't gone away. If anything, the briefing shows that it has scaled up massively.
It really has. The volume of errors is alarming.
The briefing cites a database maintained by a researcher named Damien Charlatan. He tracks AI hallucinations in court filings worldwide. And as of mid-2026, his database has logged 1,641 individual cases of hallucinated citations.
Over 1,600.
1,641 times that a fake case was submitted to a court. And the consequences, what the briefing calls the sanctions curve, are just going vertical. We aren't talking about a $5,000 slap on the wrist anymore. Look at the Couvret v. Wisnowski case out of the District of Oregon in April 2026.
Yes. Couvret represents a severe paradigm shift in how the judiciary is handling this.
What did they do?
Well, in Couvret, the attorney submitted a pleading completely riddled with AI-generated fabrications. But this time, the judge didn't just issue a flat nominal fine. The court fined the attorney per fabrication.
Oh, wow, like line by line.
Exactly. They looked at every single fake citation, every fake quotation, and attached a dollar amount to it. The total sanction in that single matter climbed past $110,000.
Over $100,000 for not proofreading a robot's homework.
That is a loud, undeniable signal from the bench. The judiciary has officially exited the gentle warning phase of this technology. Ignorance of how a language model works is just no longer a valid excuse in federal court.
But I have to ask, who is actually making these catastrophic mistakes now? Because surely the massive white shoe corporate law firms with armies of paralegals and huge IT departments have figured this out by 2026.
You are absolutely correct. The large firms largely have it under control. They use secured, enterprise-grade tools that don't hallucinate as much. But a Stanford analysis highlighted in the briefing reveals a critical demographic shift in where these errors are actually coming from.
Who is it then?
The fabrications are heavily concentrated among solo practitioners, small under-resourced firms, and increasingly pro se litigants.
Pro se litigants. Okay, for our listeners who might not know, a pro se litigant is someone representing themselves in court without an attorney.
Right, they are going it alone.
And this is where the story gets really interesting and honestly a bit tragic. Let's look at the pro se litigant. These are people trying to navigate a highly complex, often incredibly hostile legal system entirely on their own. Maybe they are fighting an eviction or fighting a predatory debt collection.
It's incredibly stressful.
And they turn to a chatbot because they literally cannot afford to hire an attorney. They are effectively using the public AI model as a free public defender.
Yes, they're just looking for a lifeline in a system that is drowning them.
And the cruel irony is, because they don't have a formal legal education, they are the exact people who completely lack the training to spot a hallucinated case.
They don't know what they don't know.
If the AI tells them, according to Smith v. Jones, you don't have to pay this debt, they believe it. They are the exact people who least expect a computer to lie to them with such an authoritative, formal tone.
It is a profound access to justice issue. The very tool that promises to democratize legal knowledge and sort of level the playing field for the poor is actively harming the most vulnerable users because of its reliability flaws.
It's heartbreaking, really.
It is. And what terrifies the judiciary even more is that this misuse is no longer confined to just the trial courts. The briefing notes that these fabrications have now reached the appellate level. Cases like Park v. Kim in the Second Circuit Court of Appeals.
Wait, why is it worse if it happens at the appellate level? A court is a court, right?
Not quite. Because appellate courts make binding precedent. Trial courts resolve individual disputes between two parties, but appellate courts make the rules that everyone else in that jurisdiction has to follow.
Oh, I see.
So if a fabricated authority slips past an overworked appellate panel and they cite that fake case in their published opinion, it risks being laundered into actual binding law. A hallucination literally becomes reality.
That is a deeply chilling thought, a fake case becoming real law because no one stopped to check the math.
Exactly.
So the core lesson that the bench is internalizing from all these sanctions and near misses isn't just we need to ban ChatGPT, it is that human verification is a non-negotiable absolute.
Precisely. The system only survives if the human verifies the output, and that rigorous discipline of verification is exactly what allows a certain vanguard of judges to start using these tools safely, creatively, and out in the open.
Let's talk about that vanguard, because I found this section of the briefing absolutely captivating. While a large chunk of the legal profession is either hiding their AI use in the shadows, like in Illinois, or stumbling blindly into six-figure sanctions, you have a small group of highly respected, influential judges experimenting with total transparency.
Yes, they're leading by example.
And the star of this section is Judge Kevin Newsom of the 11th Circuit Court of Appeals. Walk us through his methodology, specifically looking at the Snell case, because the facts of this case are just wonderfully bizarre.
They really are. Snell v. United Specialty Insurance from 2024 is a perfect, highly accessible vehicle for this discussion. It was a big insurance dispute. A homeowner had an insurance policy and someone was injured on the property.
Okay.
The entire multi-million-dollar case hinged on the legal definition of a single word in the insurance contract. Specifically, does installing an in-ground trampoline count as landscaping?
Only in a lawsuit.
Right. If it is landscaping, the insurance covers the injury. If it is not landscaping, the insurance company pays absolutely nothing.
Which is such a classic, infuriating legal argument. You have brilliant, high-priced lawyers in custom suits arguing for hours over whether digging a hole in the dirt for a bouncy surface constitutes landscaping.
Welcome to the practice of law.
So how does Judge Newsom approach a puzzle like this?
To understand his approach, you have to understand his judicial philosophy. Judge Newsom is a textualist.
What does that mean?
In constitutional and statutory law, textualism is a massive, dominant theory. It essentially argues that a judge shouldn't try to guess the secret intent of the legislators who wrote a law or the hidden motives of the people who signed a contract.
Don't read minds, read the page.
Exactly. A judge should look solely at the text and seek the ordinary meaning of the words at the exact time they were written. How would an average, ordinary person walking down the street understand the word landscaping?
Okay, but traditionally, wouldn't a textualist judge just pull a heavy dictionary off the shelf in their chambers?
That's exactly what they've done for decades. They would consult Black's Law Dictionary or Merriam-Webster. But in his concurrence in Snell, Judge Newsom proposed a new method, something he himself actually predicted many in the legal establishment would reflexively condemn as heresy.
Dramatic. What did he do?
He and his clerk queried large language models. They opened ChatGPT, Google's Gemini, and Anthropic's Claude to see how the machines defined landscaping.
He literally typed into the prompt box, "Is a trampoline landscaping?"
He did. And his rationale for doing this was actually deeply grounded in linguistic theory. He argued that these large language models are not just fancy calculators, they are statistical mirrors of humanity.
Mirrors of humanity.
Yeah, because they are trained on billions of parameters of human text. Everything from Ernest Hemingway novels and PhD dissertations to gossip magazines, obscure blog posts, and Reddit comment threads.
Oh, right. They read everything.
Therefore, he argued, these models have essentially absorbed how ordinary people actually use language in everyday messy life. They might actually be better at capturing the ordinary meaning of a word than a curated, sterile, highly academic dictionary written by a few isolated lexicographers.
That is a fascinating argument.
He even followed this up in a subsequent case with a rigorous mini-experiment. He ran the phrase physically restrained 10 different times across 3 different models to see if the semantic consensus held up over multiple generations.
Okay, I see the intellectual appeal of his argument. I really do. But I have to push back on this.
Go for it.
I understand the logic. But if a large language model is trained on the entirety of the internet, including Twitter arguments, Reddit threads, and YouTube comments, is it really giving us the distilled ordinary meaning of a carefully drafted legal contract? Or is it just giving us the most statistically popular internet slang?
That's a huge debate right now.
Right. Is a language model really any different or better than a judge in the 1800s consulting Noah Webster's dictionary? It feels like we are just replacing the transparent, accountable authority of a human lexicographer with the opaque, totally unexplainable authority of an algorithm.
Your skepticism is incredibly valid. And honestly, it mirrors the exact fierce debate the legal community is having right now over textualism and AI. But the briefing is very careful to point out a crucial mechanical detail about how Judge Newsom actually used this tool. His experiments were contained entirely within what lawyers call dicta.
Dicta. Let's explain what that means for a layperson.
In a judicial opinion, there is the actual binding legal decision that resolves the case and sets the precedent for the future. And then there is dicta.
Which is what?
Dicta is the tangential commentary, the sort of philosophical musings, the, by the way, observations that a judge writes in the margins of the opinion. Dicta is not legally binding. The actual Snell case and the subsequent cases resolved on other entirely traditional legal grounds. Judge Newsom wasn't using the AI to decide the outcome of the case. He was using his written opinion to probe the edges of the methodology out in the open.
So he wasn't letting the AI rule on the trampoline. He was just testing the water, saying, hey, legal community, look at this tool. Should we be using this?
Exactly. He was deliberately sparking a debate. And he is not alone in this vanguard. Judge John Nalbandian of the Sixth Circuit Court of Appeals has been similarly outspoken. He has argued aggressively against categorical blanket bans on AI in the courts, suggesting that client demand for speed and efficiency will eventually force the profession into responsible adoption.
Like you can't fight the tide.
Exactly. Over in the UK, an English Lord Justice openly called ChatGPT jolly useful for summarizing settled, uncontroversial areas of law.
Jolly useful. I love that.
It's very British. But what unites this vanguard isn't a blind tech utopian faith in the software. It's their method. They share 4 core principles: open disclosure of the use, keeping the use narrow and tightly defined, applying strict human verification, and most importantly, never letting the model make the final adjudicative decision.
So by being transparent, they are modeling the exact behavior they want to see from the practicing lawyers. They are showing that you can use this stuff, but you have to show your work and check your answers.
Bingo.
Which brings up the massive elephant in the room that hangs over all of this: ethics.
Yeah.
With all this new technology, all these hallucinations, all these differing state policies, do we need an entirely new rule book for the AI era? Jack Russo's briefing tackles this question head-on, and the answer is surprisingly elegant.
The answer is just a flat no. We do not need to reinvent the wheel. The American Bar Association, the ABA, made this absolutely explicit in Formal Opinion 512, which was published in July 2024.
What did the opinion say?
They reviewed the existing model rules of professional conduct, the age-old duties of competence, confidentiality, and candor to the tribunal, and concluded that they apply perfectly to generative AI.
The briefing highlights a specific philosophical quote from that ABA opinion that I think is just profound. It really gets to the actual mechanics of the technology.
Yeah.
The ABA noted that AI systems lack the ability to understand the meaning of the text they generate.
That is the whole ballgame right there.
Think about how deep that is. It's just math. It's an incredibly complex statistical engine predicting the next most likely word in a sequence. It doesn't know what a contract is.
It doesn't know what justice is.
Exactly. It doesn't feel justice. And because the system doesn't truly understand the text, a lawyer or a judge cannot ever ethically outsource their professional judgment to it.
That is the philosophical core of the ethics debate. The ethical duties were always there. The technology just made those duties load-bearing in a completely new way. You can't blame the hammer if you build a crooked house, and you can't blame the language model if you file a bad brief.
That's a great way to put it.
But where this conversation gets highly complex and where the briefing really shines is when we move past the philosophy and look at the empirical data on what AI actually does to a lawyer's competence and productivity in the real world. The briefing points to these fascinating randomized controlled trials conducted by researchers at the University of Minnesota.
Yes, the Minnesota RCT studies. This data blew my mind because it challenges a lot of assumptions we have about who benefits from this tech. Can you break down exactly how they measured this?
Certainly. In their first study in 2024, they wanted to see how standard GPT-4 affected legal work. They took a group of law students and lawyers and split them up. They gave them standard legal analysis tasks, drafting a memo, spotting issues in a contract, writing a complaint.
The basic blocking and tackling of law.
Right. One group did it the traditional way, and the other group had access to standard GPT-4. Then they had independent blinded graders evaluate the quality of the work.
And what did the graders find? Did the AI group blow the other group away?
Well, they found that standard GPT-4 brought massive, undeniable speed gains. The AI-assisted group finished their tasks much, much faster. But, and this is critical, the actual quality improvements in the legal arguments were only slight and very inconsistent. Standard AI made the lawyers faster, but it didn't necessarily make their legal reasoning sharper.
Interesting. Faster, but not necessarily better.
However, there was a fascinating sub-finding. The lowest skilled participants in the study, the ones who struggled the most with drafting, gained the most benefit in quality. The AI acted as a massive equalizer, bringing the bottom tier up to the middle.
That makes sense. It helps you get past the blank page anxiety and gives you a competent first draft.
Exactly.
But then they ran a second study the next year, right?
Yes. Look at the 2025 follow-up study. The researchers upgraded the technology. Instead of just letting the participants use raw, open-ended GPT-4, they gave them RAG tools. RAG stands for Retrieval Augmented Generation.
Okay, we need to pause here because RAG is a huge buzzword in tech right now. But a lot of people don't understand how it physically works. What makes a RAG different from just typing a question into regular ChatGPT?
Let's look at the mechanics. When you ask raw ChatGPT a legal question, it pulls an answer from its vast, generalized training data, which includes everything from Wikipedia to old Reddit posts.
Yeah.
That is why it hallucinates. It's just pulling from the ether.
Right.
RAG changes the architecture entirely. With a RAG system, the AI is tethered to a closed, verified database, in this case, a database of actual verified legal statutes and case law. When you ask a RAG system a question, it performs a search of the verified database first.
Like a traditional search engine.
Exactly. It retrieves the specific relevant legal documents, then it feeds those specific documents to the language model and essentially says, answer the user's question, but only use the information contained in these specific documents.
Oh, I love that. Let me try an analogy here to see if I'm getting it. Raw GPT-4 is like a brilliant, highly charismatic student taking an open-ended, closed book exam. They have a vast memory, but if they forget a detail, they are confident enough to just invent an incredibly plausible-sounding lie to fill the gap.
Yes, exactly.
But a RAG system is like forcing that exact same brilliant student to take an open book test, and the only book allowed in the room is the verified textbook you literally just handed them. They can synthesize the answer beautifully, but they are physically constrained by the facts in the book.
That is an absolutely perfect analogy. The open book constraint is the mechanism that drastically reduces hallucinations. And the results in the 2025 Minnesota study using RAG were just staggering.
How so?
With the RAG tools, the productivity didn't just edge up, it skyrocketed.
Yeah.
The researchers measured jumps in productivity ranging from 34% to 140% depending on the task.
Wow.
And this time, unlike the 2024 study, they saw real, measurable quality improvements across the board and markedly fewer hallucinations. The output wasn't just faster, it was objectively better lawyering.
Okay, wait, let's pause on that number. 140% more productive. I want to connect this back to the ethics discussion we just had. If a tool can make an attorney more than twice as fast and actually improve the substantive quality of their legal analysis, we have a paradox.
What's the paradox?
We talked earlier about how nearly half of the federal judges surveyed reported having zero AI training. So my question is, at what point does abstaining from AI become an ethical violation?
Oh, that is the big question.
Right. If you are a client, a small business owner, paying a law firm $800 an hour to draft a contract, and that law firm refuses to use a secure RGA to cuts the billable time in half while improving the quality, Aren't they violating the duty of competence by being willfully, stubbornly inefficient?
This raises an incredibly important question, and it is the absolute crux of what the briefing defines as the leveling effect. As the Minnesota researchers noted, AI lifts the floor of baseline competence far faster than it raises the ceiling of elite excellence.
What does that mean in practice?
It takes a mediocre, slow drafter and makes them highly proficient, much faster than it takes a brilliant Supreme Court litigator and makes them a god.
Which is a massive paradigm shift for the justice system as a whole.
Enormous. Think about the reality of the system right now. Think about an overburdened state trial judge with a 1,000-case docket who is working nights and weekends just to keep their head above water. Or think about an under-resourced public defender handling 3 times the recommended caseload.
They are drowning.
Exactly. For them, the efficiencies of a tool that boosts productivity by 140% are not just a luxury. They're almost impossible to ethically refuse. The system is simply too strained to ignore a lifeline of that magnitude. It shifts the entire ethical conversation. We are rapidly moving from asking, is it safe to use this tool, to asking, is it professional negligence to ignore it?
Which is a terrifyingly fast shift in consensus. We are basically saying that these junior assistants, these open book test takers, are going to become mandatory equipment for basic survival in the legal profession within the next few years.
I believe they will.
But Jack Russo's briefing doesn't stop at the present day. It demands that we look forward. Because what happens when these tools stop being just narrow assistants? What happens when the open book student becomes smarter than the professor? We need to talk about the forecast. We need to talk about AGI and ASI.
Yes, this is where the briefing pushes us to the horizon. We are talking about AGI, artificial general intelligence. These are hypothetical systems that equal or exceed human cognitive capabilities across virtually all economically valuable tasks. And beyond that, ASI, artificial superintelligence, which significantly surpasses human capabilities in every domain.
Sounds daunting.
The briefing is careful to flag this as a forecast, not current fact, but it forces the legal community to grapple with the implications now, before it arrives.
Before we get into the deep philosophy of the horizon, we really have to do some vital myth busting. Because if you read tech blogs or listen to certain legal podcasts, the world is full of wild stories right now that are just flat out false. People think the future is already here. Let's kill 2 of the biggest myths right away. First, the myth of the Estonian AI judge.
Oh, this one drives me crazy.
You hear this all the time at legal tech conferences, that the country of Estonia has literally deployed a robot judge that autonomously decides small claims court cases without a human involved.
It is a total fabrication and an incredibly persistent one. The briefing notes that Estonia's own Ministry of Justice had to formally come out and debunk the story. They explicitly stated that no such robotic judge project ever existed in their system.
So it's completely fake.
Entirely fake. It is a cautionary tale about how eager people are to believe that the sci-fi future is already functioning in Europe.
And the second myth is one that caused a massive existential panic in law schools a couple of years ago. The claim that GPT-4 passed the uniform bar exam in the 90th percentile. Everyone read that headline and thought, oh my God, the robots are instantly better at law than 90% of graduating law students. We are all obsolete.
That claim was drastically overstated and fundamentally misunderstood. Let's explain how percentiles actually work in the context of the bar exam. The original claim compared the AI's score against everyone who took the test, including those who failed miserably.
Right.
But as the briefing highlights, a rigorous, peer-reviewed reanalysis of that data was published. When the researchers compared GPT-4's performance only against test takers who actually passed the bar and became lawyers, the AI's performance plummeted. It was closer to the 48th percentile overall.
Oh, wow. That's a huge drop.
And on the written essays, the part that requires actual legal synthesis and human reasoning, it was near the 15th percentile.
Which, to be fair, is still a mind-bending achievement for a piece of software. But it proves it is not a super lawyer. It's effectively a C- law student who really struggles with the essays.
Precisely. It's not taking over the top-tier jobs yet.
But let's assume the technology curve continues, the billions of dollars being poured into Silicon Valley yield results, and eventually we hit that AGI horizon. The AI goes from a C- student to the smartest entity on Earth. This is where the briefing poses the most profound constitutional questions of the entire document. Today, as we discussed with the Red Zone, we confidently say the human judge must decide, and the adjudicative core is non-delegable. But why do we actually say that?
We say it mostly because we know the machine currently makes mistakes. We know it hallucinates cases like in Mata.
Right.
The current prohibitive rule relies, quietly, on the empirical, measurable fact that human judges are still vastly more reliable at complex reasoning and fact-finding than language models. Our rule is based on the technology's current incompetence.
So what does this all mean when that premise is no longer true? I want you to imagine a Tuesday in 2032, a new AI system drops. A major university runs a massive, peer-reviewed, double-blind study on this new system, and the data is undeniable. This AI judge makes 0 errors of law.
Okay.
It demonstrates mathematically 0 racial or gender bias in its sentencing. It resolves complex, multi-year commercial disputes 50 times faster than the most experienced human judge on the federal bench. The machine is measurably, undeniably, and consistently more accurate than any human could ever be.
This is the constitutional horizon that the Russo briefing forces us to face. When the machine surpasses us in accuracy, the entire justification for the red zone, the strict prohibition on delegating the adjudicative function, completely collapses. If the justification was based solely on the idea that humans make fewer errors, what happens when humans make more?
It forces a massive philosophical crisis. Does due process require a human judge because we believe humans are more accurate at finding the objective truth? Or does due process require a human judge because there is a fundamental, unquantifiable dignity in being judged by a fellow human being? Someone who is accountable to the community, who understands mercy, who knows what it actually feels like to make a mistake.
Are we paying for cold accuracy, or are we paying for shared humanity?
Exact.
That is the ultimate question. The entire history of the common law has never really had to separate those two concepts before. Human judgment was the only judgment available, so accuracy and humanity were just bundled together. But Jack Russo's analysis synthesizes this beautifully.
How does he resolve it?
The briefing concludes that the judicial institutions that will survive this coming wave of AGI are not the ones pretending the technology won't improve. The survivors will be the courts that affirmatively anchor the non-delegable core of judging firmly in human accountability and human dignity. If we anchor our system just in the temporary fact that machines currently make mistakes, that anchor will drag the moment the error rate drops to 0.
It is such a powerful reframing of the profession. We have to proactively decide why we want humans in the loop, beyond just double-checking citations. Which brings us back to the image we started with, the imposing federal courtroom, the judge looking at the monitor. Right now, in the summer of 2026, the judge is using that AI as a fast, brilliant, but slightly unreliable clerk.
Yes, they're seeking the efficiency of the machine, but retaining the heavy, necessary burden of judgment.
And that is exactly where the balance should be today. But the pace of change is relentless. The laboratories of democracy in the state courts, Illinois, Delaware, New Jersey, are going to continue testing the bounds of policy. The federal system will slowly have to wake up to the absolute necessity of unified governance. The sanctions curve will continue to brutally punish the careless lawyers who fail to verify, while the vanguard of judges like Kevin Newsom will continue to transparently map the ethical ways forward.
It is an incredible time to watch the law evolve.
It really is. Which leaves us with one final, lingering thought to mull over as this technology rapidly catches up to the law. If that day comes, if an artificial general intelligence eventually becomes 10 times more accurate, 10 times faster, and totally immune to the biases that plague human decision-making, could demanding a human judge actually become a violation of your right to a fair trial? If the machine is statistically undeniably fairer than the human, is it unjust to demand the human? It's something to seriously explore on your own.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at jack@computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.